Hello everyone, myself Priti, Assistant Professor of Law in IIMT College of Law, Greater Noida. Today we are discussing concept of treaties in international law. The concept of treaties in international law as a source of international law. As you all know, international treaties are the source of international law, and today we discuss it as a source of international law. First, we come at the point that the introduction of international treaties. Article 38, Clause 1 of the International Court of Justice Statute identifies treaties as a source of law, along with general principles and customs. Treaties occupy a very eminent position in international law, drafted by the International Law Commission of UN and taking force on 27th January 1980. The Vienna Convention on the Law of Treaties sets out some fundamental rules that how treaties becomes the source of international law. Now we can say that Article 38 Clause 1 says that treaty will be treated as a custom of as a source of international law. So we will discuss Article 38. Article 38 Clause 1 says that the court whose function is to decide in accordance with international law such disputes are submitted to it shall apply international conventions, that is treaty, international convention treaty, whether general or particular, establishing rules expressly recognized by the contesting states. B. Also international customs as evidence of general practice accepted as law. And the next one is the general principles of law recognized by the civilized nations. And the last one is that is subject to the provisions of Article 59, judicial decisions, the teaching of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. So, as it can be seen that there are three primary sources of international law, that is international treaties, custom, and general principles of law. Additionally, there are two subsidiary sources also that may assist one of the identifying norms derived from the primary sources, that is judicial decision, and the teaching of the most highly qualified publicists, that is leading international law scholars. The precise meaning of all of these sources shall be elaborated in another session. Here we are elaborated only the meaning of international treaty. So, what is the meaning of international treaty under international law? Treaty in common parlance may be defined as written agreements between parties which may or may not be stated to identify and follow a set of rules. They may also be referred as pacts, agreements, charter, etc. So here we are discussing the meaning of the international treaty under international law, and this says that commonly we know that what is treaty? Treaty is an agreement between the parties which may or may not be stated to identify and follow a set of rules. The treaty may be in the form of pacts, in the form of agreements, in the form of charters, it may be in any form or etc. Treaty have been classified on the basis of many principles. So it is classified according to the principles on the basis of object. They have been classified as political treaties. So on the basis of object, it is classified as political treaties, including alliances and disarmament treaties, constitutional and administrative treaties, for example, WHO's constitution, which is responsible for setting up of international body and to regulate its affairs. Commercial treaties like trade and fishery agreements, criminal treaties like define international crimes and may require the extradited offenders, treaties codifying article. Next is Article 26 of the Vienna Convention on the Law of Treaties deals with the Latin maxim pacta sunt servanda. Law of treaty deals with what? It deals with Latin maxim, that is pacta sunt servanda, and the meaning of this is every signatory is to follow the treaty in good faith and is binding upon them. This forms the basis of every international agreement So the point says that the Vienna Convention, the Article 26 of the Vienna Convention on the Law of Treaties, deals with a Latin maxim that is pacta sunt servanda. It is every signatory is to follow the treaty in good faith and is binding upon them. And it is the basis of the every international agreement. So a country that has not signed the treaty has no obligation to follow its norms, meaning thereby that simply you can say that treaty will be followed by the signatory. It's this forms the basis of every international agreement, and who the member country who has not signed the treaty has no obligation to follow. However, like the ICJ had stated the North Continental Shelf case, in a case the International Court of Justice stated that some treaties may give rise to international conduct, custom, and be of a fundamentally norm creating character. So, here we are discussing the case that is North Continental Shelf case, in which the International Court of Justice says that some treaties may give rise to international custom, conduct, and we are fundamentally norm creating characters. So till now we are discussing the introduction as a source of law, introduction of treaty as a source of law, and after that meaning of treaty under international law. And now we are forwarding towards the kinds of treaties. There are two kinds of treaties, that is law-making treaties and the contractual treaties. So first we discuss law-making treaties. This term actually refers to the content and the subject matter of treaty, which instead of being contractual shall be statutory. The term actually refers to the content and the subject matter of the treaty, which instead of being contractual shall be statutory. In cases of law-making treaties, the obligations are independent and they don't require a subsequent fulfillment of rules by other parties to it. These obligations have binding force, and the parties to these treaties be following following the terms. That simply by name we can say that law-making treaties are those treaties which are statutory in nature, means the obligations are independent, means to follow these obligations there is no requirement of any other rules or any other kind of fulfillment by the other party. It should be followed by the party. They are law-making treaties, and these obligations have binding force on the parties of the treaties, and the parties of the treaties must follow the terms. That is law-making treaties. The next is contractual treaties. Contractual treaties are usually applicable to treaties having a small number of parties and are most commonly seen in bilateral treaties. Bilateral treaties are those which are between the two states or the two nations, or we can say the two parties. There are treaties where parties are mutually dependent on each other for specific treatment to gain benefit and have rights and obligations towards each other. So they are usually applicable to treaties having a small number of parties, mostly bilateral treaties, and the treaties are mutually depend on each other for specific treatment for the gain or the rights or the obligations, etc. The scope of treaties is mostly perceived in a contractual framework. Unlike lawmaking treaties, which sets out rules for conduct, rights and duties between parties, which have to take effect on the conclusion of the treaty. Contractual treaties are usually limited to, say, exchange of goods, which one state might not possess and require or convinces. Here, one party agrees to provide the other party something it needs for something else in return. So, the scope of treaty is con- perceived in a contractual framework. It's different from lawmaking treaties. Lawmaking treaties sets out rules for the conducts, rights, and duties of the parties. And in contractual treaties, there are no rules, there are no set of rules which will be followed for the conduct or rights or duties. Contractual treaties like say exchange of goods which one party state might not possess and require, or conveyances, or one party agrees to provide the other something in need for something else or in return. So we can say like barter system. And after that kind of the treaties, we will forward toward the binding force of treaties, that in which manner the treaties have the binding force, have the effect of the binding between the parties. So for that purpose there is a convention, that is Vienna Convention on the Law of Treaties, that 1969. Vienna Convention on the Law of Treaties 1969 covers certain points. Some of the points are as follows: that first, the International Law Commission of the United Nations drafted the Vienna Convention on the Law of Treaties, which was adopted on May 23rd, 1969, entering into force on January 27, 1980. It is an international agreement between the states to govern and regulate treaties. Article 1 of the Vienna Convention says that it is applicable to treaties between the state. It is applicable to treaties between the states. It is also applicable to treaties entered into by international organization. So Article 1 of the Vienna Convention says that the treaties will be applicable on states and also by the international organizations who entered in the treaty. The not on all organizations. It will applicable on those organizations which will entered under those treaties. Article 2 further defines ratification, approval, and other terms which have the meaning under the binding force of the treaties. And the treaties are also have the invalidity. So we can say that treaties may become invalid because of the certain points. And for that purpose, we will discuss part 5th of the Vienna Convention on the Law of Treaties 1969. Is particularly section 2 deals with the invalidity of treaties. Article 46 to 53 sets out the way to invalidate a treaty, that is, make them void and unenforceable under international law. So, by the term invalidity of treaty, we are discussing under Article 46 to 53 of the Vienna Convention on the Law of the Treaties, that what are the ways to invalidate a treaty? What are the ways to make them void? What are the ways to make them unenforceable under international law? There are various reasons, there are several reasons as to why an internationally binding treaty may be declared as invalid. Why an international treaty becomes unenforceable. There are certain reasons behind making them unenforceable. Some of them are discussed here. Like Article 46 of the Law of the Treaties talks about willingness of the state to invalidate and conclude the treaty on the ground that it goes against the internal law. So what Article 46 says that Article 46 says that there is a willingness of the state, willingness of the nations to invalidate that treaty or to conclude the treaty as it is against the internal law of the nation. So on the basis of this reason, a treaty may become invalidate or unenforceable. Article 48 talks about invalidation on the ground of presence of errors in a treaty. The next is Article 48. Article 48 says that a treaty becomes invalidate or unenforceable on the ground that if it had some errors, if there are some errors in the treaty, then Article 48 says that that treaty will become invalidate. Next is if a state has become a signatory to a treaty due to fraudulent act or conduct of another state who is also a signatory to the treaty. Such a state may invoke invalidating the treaty on the ground of consent being obtained by fraud. So here we are saying that if the member of a treaty or a signatory of a treaty becomes the member of the treaty due to fraudulent act or conduct of another state may invoke invalidating the treaty on the grounds that his consent was obtained by fraud. Consent shall be invalidate if it is obtained by coercing the representative of the state or by threatening the use of force against a state. So the next point is also about the consent. In earlier point, we also discussed that the consent is obtained by a due to a fraudulent act or by a fraudulent act. Here also we are saying that the consent is obtained by coercing the representative of the state or by threatening the use of force against a state. The next is treaties. If treaties that are in conflict with just cognizance, then they also become unenforceable, unbinding, or invalidate. So there are certain reasons we are discussed that on what grounds treaties become the treaties becomes invalidate. So the reasons are Article 46 given in Article 46 of the law of the treaties, Article 48, and if the consent is given by, obtained by a fraudulent act or by coercing the representative of the state, then the treaty become unenforceable or invalidate. Next is termination of treaty. A treaty can also be terminated. So how it is terminated? The treaty is terminated under two headings like withdrawal if the withdrawal is self-explanatory if the parties or the signatory of the treaty withdrawal from that treaty from withdrawal from the treaty, then the treaty will be deemed as terminated. And the next is suspension and termination. So suspension and termination may be by implied by the conclusion of a later treaty as a consequence of its breach, impossibility of performance, fundamental change of circumstances, a rift of diplomatic or consular relations. So these points comes under the suspension of and termination. So from the overall discussion, we can conclude that the Vienna Convention on the Law of the Treaties lays down basic and fundamental principles to govern treaties. The main principles on which the convention operates is pacta sunt servanda. That is, all treaties must be followed in good force. It provides for various provisions such as ratifications, reservation, approval, conclusion, withdrawal, invalidation, termination of a treaty, etc. The convention is legally binding on its parties. That is, the treaty or the convention is legally binding on its party. So, in today's session, we discussed all the points from starting. We can revise for you. Concept we are discussing the topic concept of treaties in international law, and under this we discuss the meaning. For the meaning, we read the article 31 clause 1 of article 38, sorry, article 38 clause 1 of the International Court of Justice that says that international treaty is the source of source of international law. And for that, we introduce the treaty as a source of law, the International Law Commission of the UN, and taking force on 27 January 1980 through the Vienna Convention on the Law of the Treaties. And after that, we discuss the meaning of the treaty. Meaning of the treaty is very simple. Is we can say that it is a written agreement between the parties, and here the parties are the nations or the international organizations, which may or may not be stated to identify set of rules, that is agreements, charters, pacts, etc. Treaties, there next we discuss the classification of treaties, and after that we discuss the kind of treaties. Kind of treaties, there are two kind of treaties: law making treaties and contractual treaties. Law making treaties shall be statutory and contractual treaties commonly seen in bilateral treaties. Specific treatment to gain benefits and have rights and obligations towards each other in contractual treaties. And the scope of treaties perceived in a contractual framework. There is a difference between lawmaking treaties and contractual treaties. Lawmaking treaties sets rules for the conduct, right, and duties. But in case of contractual treaties, are usually limited to say exchange of goods, which one state might not have or might not possess, or the state requires that. Here, one party agrees to provide the other party something it need for something else in return. And next we discuss the binding force of treaties. Binding force of treaties, the Vienna Convention on the Law of Treaties 1969, and under that we discuss Article 1, Article 2, and the reasons. The next we discuss the invalidity of treaty. Under the invalidity of treaty, this is the part fifth of the Vienna Convention of the Law of the Treaties, particularly section 2, which deals with the invalidity of treaties. And under that, the reasons we discuss Article 46, Article 48, and if the consent of the state or the signatory is obtained due to fraudulent act or is obtained by coercing the representative of the state, that on that reason it become invalidated. And after that, a treaty will be terminated. Treaty will be terminated on the grounds that if withdrawal is there or if suspension or termination is there. So we are concluding today's session. Thank you so much, guys, for the participation in this session, and I hope you will understand the international treaty as a source of international law. Thank you.